P. Diddy's lawyer just up and quit, or one of his lawyers.
Did he do it?
And so the headlines, of course, are making the worst assumptions. Of course, they're probably saying, "Oh, I wonder what he uncovered, or what did he find out? That's why he quit." And so I thought this would be good for us to chat about, because is there a simpler explanation? I'm sure that lawyers quit cases all the time. So let's look into that. I'll go ahead and state what the legal documents said. Anthony Rico stated, quote, "Under no circumstances can I continue to effectively serve as counsel for Sean Combs, consistent with the ABA standards for criminal justice." Additional quote said, "There are sufficient reasons related to the protections afforded by attorney-client privilege for brevity in my application for withdrawal," end quote.
Well, I'll start us off. How about that? The first thing I think people should understand is it is in a criminal case, it's very difficult for an attorney to be let out of the case, so to speak. And there are certain rules, and the judges, because, you're essentially making the case a lot longer when that happens, because the new attorney that comes in, if that happens, it has to start from ground zero. You can kind of build on somebody else's work, but when I take over somebody's case, if something happened or whatever, and that happens frequently, I start from zero. I need to use my own work, and everybody's different in how they do it. So that's, there's a lot of reasons to not get out of the case.
And that's one of the things that you normally have to put in your motion to withdraw, is that there will be no delay.
Right. But there always is.
Of course.
There always is.
I did say that.
Yeah, and that's what you're trying to say. You're trying to say there's actually not a pending trial date right now, and there will be no delay as a result of my withdrawal.
There is a pending trial date in 2 months.
May, right? Yeah.
Yeah.
Right.
So, but the issue in this case, Anthony Rico is a very well-known defense attorney for capital cases, and P. Diddy has 5 other attorneys.
Yeah.
Okay, and so
there shouldn't be a delay.
He discussed this with lead counsel prior to quitting, and lead counsel basically isn't opposing it. The prosecution isn't opposing it, but there are a myriad of reasons why a person might drop out of a case.
And I think that's
not getting paid.
Right. Well, let's talk about what people think. So generally,
been there, done that.
Yeah.
Generally, you see the memes of this attorney is so terrible and he represented Osama bin Laden. Diddy must be way worse than him. But that
what
people
does he know
see
that
an
we
attorney.
don't?
There must be something terrible, but it may be a very simple solution. It may not be that he found out some terrible thing. Right. And don't get me wrong. Don't get me twisted. I think Diddy's a terrible human, and he's going down. But I'm saying that I don't think the attorney necessarily got out of the case because
he's represented some pretty nasty people.
And there's a lot of reasons you get out. Like
probably
you talk about money. You talk about you know what you believe is right to do. Not saying you're innocent, but the client won't follow your lawyer's advice.
Right. So this guy could have a very strong opinion. Is like, this is the only way to correctly defend this guy, and all 5 other attorneys say, I want to go a different direction with the defense, right? And the defendant wants to go the other direction. Well, ethically, he can say, we have irreconcilable differences about how to go about and defend this case, and I can't be a part of whatever their depending.
This committee can be. I think the distinction to me is that people need to understand is it may not be a moral distinction. It's more of a this is how I would like to try the case, and I can't try it the other direction. Not because I think it's the wrong thing to do, but I think it's the wrong thing to do in this situation when I'm working, like in the process of my job. Like, Sean, you did criminal defense for a long time. I mean, and you've been a judge and all kind of stuff. I mean, it's tough. You have 2 separate avenues that you may want to go when you're trying a case. And if me and you were trying a case and I'm going A and you're going Z, we can't work together on it. You know what I mean?
It's not going to work out at all. And there's so many things. Obviously, the media wants to report on it, wants you to come to some conclusion that all this stuff that they have found out in the discovery of the case is just so repugnant that this guy's out. It's like, no, he represented Osama bin Laden,
right?
And some, we represent people in criminal defense that are guilty all of the time.
Right.
Because obviously we still have to review the evidence, make sure that the state can prove them guilty beyond a reasonable doubt, give them good objective advice about what to do.
And the main one on those is the charge the correct charge?
Correct.
We talk about that all the time.
Oh, yeah.
The guy may be completely guilty, but it may be to a lesser charge. That's the kind of stuff you're looking for.
You could have a conversation that was unintended that could lead you to make a determination like this that you have to get out.
Right.
Say, a client, comes to you and says, all right, this is what happened. And you say, okay, we're going to see what we can do to help you, see what we can do to minimize some of this stuff, get, maybe work out a case. And then later on, the client changes their mind. No, you know what? I want to go to trial.
Yep.
And this is what I'm going to tell. I'm going to say that this happened. Well, right then, you cannot put your client on the stand under the professional rules that lawyers have to follow, and allow him to lie.
Right.
So you could have a casual conversation with your client later on down the line where he says, you know what, I'm going to say this or something, and you would be forced to withdraw. And most of the time when you are withdrawing, you can't give an explanation.
No.
Because it's always going to involve privileged communications between yourself and the client. It's just, so it always seems mysterious.
Right.
But the judges generally get that, when you say that, it's obviously something that is, likely going to lead to you having to breach the rules of professional responsibility, which you cannot do.
Right.
So then if that's the case, so I understand, like, that made perfect sense to me when it was like attorney-client privilege. Of course you can't talk about that. Mm-hmm. Why would you ever give a reason then? Like, if you were an attorney, like, why? It seems like you could always say that, right?
Generally, that's always going to be the reason.
Yeah.
It's always going to be the reason that I have to withdraw based on the rules of professional conduct.
Yeah, and then you don't have to give any
and there's sometimes you can, but I mean that really gives the judge the discretion, and we've talked about judges' discretion a few times on here, and sometimes when you're talking about like a temporary restraining order, the judge's discretion is going to lean towards the safety because they're not going to know all the facts. In this type of situation, the judge is going to lean towards the attorney. He's an officer or she's an officer of the court, and if you pry, then you start to make this attorney become vulnerable to the ethics board and everything else.
Yeah.
So the judge is going to give you more leeway with that. But there are certain, especially in civil cases when you say, and that's a little bit less lenient in civil cases. They're like, why are you trying to get out of this thing? And you got to go, look, here's what happened. They're lying to me, that kind of thing.
Yeah.
But in criminal, they're going to give you a little bit more grace to get out of it versus a civil case on that type of stuff.
The only one that I ever tried to get out of is I was assigned an attempted murder case, and he had already been through 2 public defenders. And
that we call that a problem.
Yeah, right. And,
well, I mean, really, anytime people come to our law firm, especially when I was doing criminal defense, and they say, oh, yeah, well, I was already represented by so-and-so, and I fired them. And in your mind, well, so-and-so is a good lawyer
attorney.
That, was probably giving you good legal objective advice about what to do, doing the best they could to work out, whatever, or preparing your defense.
Yep.
You already kind of have to step back and say,
answer.
Exactly.
That's what it was.
Exactly. I've had clients that, were facing, 20 or 30 years. And from the moment they walked in my door, I said, you're facing 20 or 30 years.
Yeah.
And we're going to do everything we can to, make sure that they have the proper evidence, make sure there was no violation of your rights that would lead to the evidence being suppressed. But in the end of the day, 9-10 months down the road, I might be saying, you're looking at 20 or 30 years. We're going to try and do whatever we can to minimize whatever it is. And then, I've been relieved of my duties.
You're an SOB. You've done a terrible job.
Well, I mean, I tell them all the time, I'm going to be 100% honest with you, because I see attorneys in court, not ones that I would recommend to anybody, that walk in and sentence their client, and their client gets 2 or 3 years in jail, and I can see the look on the client's face to the attorney, knowing for 100% certainty that attorney probably told them, or borderline promised them that they were going to be walking out on probation.
Yep.
And the look of shock on their face tells it all. And I would much rather tell a client, you're probably going to get 2 or 3 years in jail. This is a case that normally requires confinement. I'm going to do everything I can to try to persuade the judge otherwise. And then when they do get probation, have that joker grabbing me around the neck and hugging me instead of looking at me perplexed saying, I thought I was going home today.
I heard a good expression. It's definitely not mine, but I don't even know where I heard it, but it was, you don't want a lawyer that just holds your hands to the jail cell. And that's a little bit of that, it's a little bit of, pat you on the back, everything's going to be okay, and they'll walk you right into the jail. So it's a little bit of that. One thing I want to, I know Chase, you wanted to jump in. One thing I wanted to make clear is that, this is for us and the public opinion to talk about and listen to and discuss, but this is not admissible that an attorney got out of the case. So it's not a part of the case. It's not going to affect the case. As far as like Chase said with other counsel, it shouldn't slow it down. It shouldn't change anything. But it is interesting that maybe that attorney got out.
Yeah, and I mean the worst case scenario is that he did learn something that makes it impossible for him to continue it, because we're not allowed to engage in anything that's going to continue a criminal sort of conspiracy. So if he's admitted to them, he's done all these criminal acts, and then says, well, I'm going to get out of it because of X, Y, and Z, and this is what I'm going to say. You have a duty right then and there to say, okay, I can't ask you questions on the stand, and this is what I had to do in my case. That I had to explain to the judges, like, either you have to let me out, or I have to allow my client to testify in a narrative fashion. And that right there put the judge on notice that if I were to ask him questions, that I know that what he's going to say is going to be a lie.
Yeah.
Right? And so I ethically can't say anything. So he may have gotten himself into a situation like that. But either way,
what's
it's
the
not
legal term for that, though?
Suborning perjury. There you go.
That's right. If you suborn perjury, that means you know that it's coming.
You knew that
You're asking the question,
right?
And that'll get you disbarred.
It's the same as like you got. There's a conspiracy to commit all these crimes, right?
Yeah.
And then here you are furthering this crime being actually perpetrated. By actually putting evidence out there that you know is false that might allow this stuff to go on.
Yeah.
I mean, you're aiding a conspiracy to commit these crimes.
Yeah. And I think the other thing to point out is we're not saying that he didn't find out something he didn't
No.
There could be a reason, but there's also
10 different reasons that it could be.
So
now, just,
health reasons.
My general assumption,
but also don't let it
like,
keep you up at night because you're probably not going to find out the real answer.
My general assumption is it just like the public is probably he found some stuff that he just can't personally talk about, whatever, or found something, and it's probably mixed with all of it. Sean, with prior things Diddy has said, and
he's having nightmares about baby oil.
With Chase's argument of they want to go a different route. I think it's all those combined.
Mm-hmm.
He's like,
so
I can't do all this.
Yeah, I mean, I know that P. Diddy got on the phone with his son saying, I need you to get rid of all of the pizza boxes. Yeah. And I need you to call this person to get rid of it.
Absolutely.
Well, I mean,
if it's yesterday's pizza, then why would you not throw out the pizza box?
That's what I'm saying. You could call
if he's engaged in illegal conduct, you don't want to.
Especially with Pizzagate out there, there's conspiracy. I'm a conspiracy theorist. Pizzagate's been out there for a long time. I'm not going to bring it up here.
Yeah,